Okay, in part two of our lecture this week, we're going to switch gears and talk a little bit about who can be sued in a negligence claim and then what the different levels of liability look like. So, we're going to start off by just talking in general about these different categories of employees that might be involved in a negligence claim. So, you can see here with our pyramid, we've got kind of the largest chunk of the pyramid down here. That's employee service personnel. So if we think about a sport organization, I want to use the Corn Belters as an example, so our local minor league baseball team. So if we think about the employee service personnel category for a minor league baseball team like the Corn Belters, here we're talking about kind of your frontline entry level employees, right? So people working in the box office, people working as ushers, people working in the concession area during the game, these sorts of entry level, lower level positions that tend to employ big chunks of a sport organization, right? And obviously, these people tend to have a lot of contact with fans, probably more so than the other levels of employees at most sport organizations. So they can certainly be involved in negligence claims, meaning that an employee or service personnel might act or fail to act in a way that causes injuries to a patron or a fan. And in those instances, they could be named as party to a negligence lawsuit. Now, the good thing about the employee service personnel level is that because it is the very bottom here, those folks are only accountable for their own liability, right? Meaning that certainly they can be sued, excuse me, in a negligence claim, but because they're kind of the bottom of the totem pole, they can't actually be held liable for other employees' actions. And as you'll find here, as we look at the different levels here, very rarely will a negligence lawsuit that's filed in court only name someone at the employee service personnel in their claim, right? Because typically someone in a position like that, even though they might have been at fault or the most involved in the incident, probably that person's not going to have deep pockets, right? They're not going to have the financial ability to make some kind of payment in court. So while they might be named as a party to a lawsuit, very rarely will they be the only party named in that complaint. The next level here of employees that could be involved in a negligence claim are this administrative supervisory personnel. This is basically anyone that has some kind of administrator or management role in the organization, right? Typically, these are the folks in charge of the employee service personnel, right? So, with the Corn Belters, this could be like the director of operations, this could be the marketing coordinator, this could be those folks that are sort of middle management, overseeing small staffs that fall under this administrative role. Now, as you can imagine, because they do have a management role and they do oversee other employees, they can actually be held accountable for their own liability and the liability of their employees. Meaning that potentially, if one of their employees participates in a negligent act, they can also be held liable for those actions. Okay. This is why it becomes very important once you are in some kind of management position to make sure that you're providing proper supervision of your employees, make sure you're providing proper training for those employees, because not only can their actions bring financial trouble to the sport organization, but their negligence can also be passed up to you as their administrator or manager. Okay, the last category of employee here is the corporate entity. So as you can tell, this is the top of the food chain. This is also the smallest part of our pyramid, right? So as you might imagine, corporate entity is going to be maybe for example, with the Corn Belters, this would be the president or the owner of the team, right? So again, top of the food chain, the person in charge, right? The person running the show ultimately. So, we'll talk in a minute about the level of liability that can be passed along to the corporate entity. But just know that in a lot of cases involving negligence, particularly in the sport industry, like I said, very rarely will a negligence claim only include service personnel or administrators, right? Typically, a plaintiff is going to also go after the corporate entity. And again, a lot of that goes back to the financial ability, right? So if they're actually hoping to receive compensatory damages, they probably realize that their best bet at doing so is to go after the corporate entity. All right, let's talk a little bit about how a corporate entity can be sued in a negligence claim. And how that negligence act or act of omission committed by even an employer service personnel can be passed all the way up to the corporate entity in the eyes of the court. And that occurs due to this concept of vicarious liability. So with vicarious liability, basically any negligence of an employee can be passed along all the way up to the corporate entity if the employee was acting within the scope of their employment when committing the negligent act. You might be thinking, what does that mean? What does the scope of employment mean? So I've broken that down for you a little bit here. So court, when examining the negligent actions of an employee, is going to look at these things to determine whether or not they actually fall into the scope of employment. So did the act occur within authorized time and space limits of the job, right? Did it occur during normal work hours? Did it occur at the facility or near the facility of the organization? That would certainly make it seem as though it occurred within the scope of employment. And then also, did the employee act or fail to act in some cases as part of their job duties to serve the organization? Meaning that whatever negligent act or failure occurred by the employee, that it was in the context of their typical job duties to serve the organization. It wasn't outside of that. And I'll give you an example here in a minute that showcases instances where this can be the case, where it can be outside of the scope of employment. But generally speaking, as long as the court can prove that the employee was acting within the scope of their employment when committing that negligent act, then they will allow that negligence to be passed all the way up to the corporate entity. And that's regardless of the corporate entity's knowledge of or involvement in the incident, meaning they don't even have to know the employee's name to be held liable in these cases. Okay, I said I'd tell you a little bit about an example here. So this Smith versus Gardner case is a really interesting one, showcasing vicarious liability and this concept of scope of employment. So in this case, you had a college baseball coach who was traveling with the team. So he was driving the team bus, drove the team to this nearby city, dropped the student athletes at the hotel, got everyone set up for the night, and then he decided he was going to go have a few drinks at a local bar. Okay, so he takes the team bus, drives it to a local bar, has more than a few drinks at this bar, and when driving back to the hotel later is in a car accident involving another car, and there are injuries suffered by the occupants of that car. So fast forward a little bit later, and in this case, the families of the people in the other car file a lawsuit against the university. And basically, you know, they've decided that they need to pursue a negligence claim against the university because the coach doesn't have a ton of cash and he's not going to be able to pay for these medical bills, right? So not only do they name the coach in the lawsuit, but they also name the university, and they try to prove through vicarious liability that this negligence should be passed up to the corporate entity. Remember, in these instances, the court is going to ask, you know, is this act or was this act within the scope of employment when it occurred? And in this case, Smith versus Gardner, the court essentially said no, it was not, right? Because the employee, in this case the coach, was acting outside of his typical job duties, right? He took the team bus, but he left the team hotel. He went to the bar. None of that was part of his job duties, right? He's acting outside of his typical job duties when the incident occurred. And it was also outside of typical authorized time and space limits for his job. So because of that, the court deemed that vicarious liability did not apply to this case, right? That they could only pursue action, legal action against the coach and not the university because the coach was acting outside of his scope of employment during the crash. So that's a good example of when a court does not allow vicarious liability, but there are several other cases where vicarious liability is able to move forward, meaning that the plaintiff is not only able to sue maybe the individual involved in the negligent act, but also they're able to go after the corporate entity as well. And there is a term here for acts or actions beyond that scope of employment. It's a Latin term called ultravirus acts. So these are acts that are outside of the scope of employment, and therefore the corporate entity is not liable in those cases. Okay, so just a real quick recap here of the different levels of liability in a negligence case. And again, this pyramid could be applied to any sport organization. I just did the Corn Belters, or use the Corn Belters as an example, but you could probably apply this to your own organization or department that you're currently working in to kind of see where you fall, which I would guess is probably somewhere in this employee service personnel, given your age and status. But keep in mind that as you get older and as you get more experience in the field, you're probably going to move up, right? You're going to eventually be in some kind of supervisory role. And as we discussed a few slides ago, as you kind of move up the pyramid here, so does your potential risk of liability, right? Because not only are you liable for your own actions, but now you're also liable for the actions of those working underneath you. So just keep that in mind, as you sort of move along in your career, that this concept of negligence can certainly impact you when you're at the employee service personnel level, but it can also continue to impact you once you're in a supervisory role. And it, again, just becomes more and more important to be aware of what your employees are up to, making sure you're providing proper supervision and training in an ongoing manner. Okay, quick recap of what we've covered in this module, at least as part of the video lectures. So, so far we have defined tort law and we introduced that tort law spectrum, right? So now we know kind of where all the different types of tort law fall on that spectrum, and know that we will keep bringing that spectrum up as we sort to examine other aspects of tort law beyond negligence. So that will not be the last time you see that. We also defined negligence and the 4 elements required in a negligence claim. We learned that the burden of proof is indeed on the plaintiff to prove those 4 elements, and they must prove all 4 elements in order to be successful. And then finally, we examined the different levels of liability in a negligence claim. We kind of introduced those categories of employees and discussed the level of liability that is as a result of those different categories. And finally, we introduced that concept of vicarious liability and, kind of determined how a corporate entity could be deemed negligence in a negligence claim. All right, that's all I have for you this week. So make sure that you're taking some time to review the current events that I posted in the module, as well as reading through the textbook reading if you haven't already. It goes into quite a bit more detail than I've gone in our video lecture. And then finally, you'll want to make sure that you complete the practice case study for this week, which actually involves a real life incident that occurred with a woman at a Boston Red Sox game. So in order to complete this case, you'll need to read through the article I've posted in ReggieNet and then respond to some questions. And that's all I have. Thanks. Have a good week.